Estamos live.
Good afternoon. My name is Carolina Leon. I'm a corporate partner of the law firm, and it's my privilege and pleasure to welcome all of you on behalf of Pellerani Herrera to this webinar, The New Normal for Doing Business in DR After Lockdown. We thank you for joining us. I'm honored to have with me one of our litigation partners, Felix Fernandez, and our head of the tax department, Caroline Bono. Before starting this webinar, we would like to say that if you have any questions, feel free to post them in the Q&A tab, and we will address the answers at the end of the presentation. Let's start with the corporate and labor side. I think my part is one of the more lengthy part of this webinar, so I will try to be very brief. As to the corporate part, what have we learned about what happened during the COVID? What happened during this close of operations of the company? Most of the contracts had the force majeure provisions very light, didn't provide pandemic events, and under the civil code here for force majeure being conceived as it is, need to be unpredictable and unavoidable. I mean, couldn't be avoided. And not all these situations in a contract could be categorized as force majeure events. In any case, what we had encountered during this pandemic is that most of the contracts had a very light provision of force majeure. So we need to revisit this. It's one of the things that we need to do, revisit force majeure provisions in the contracts, and from now on, try to establish mechanics to follow on what will happen in an event like this. Because at the end, no one wants to be exempted from the compliance of a pertinent obligation in a contract. So let's move on to the bylaws of a company. What happened here? Although corporate law established face-to-face meetings, non-face-to-face meetings, the bylaws of the company needs to be more, let's describe more, needs to be more descriptive on the way these non-face-to-face meetings will take place. For example, the voting rules. That lead me to the next topic, which is the digital signature. All the members of the board, all the members of the committees, if we have committees in the board, and the shareholders needs to have digital signatures in accordance with the e-commerce law of the Dominican Republic, which is 126 as of 2002. The digital signature needs to be certified by a certified entity here in the Dominican Republic. This is a must, since this avoid that the companies that are still running are prevented from taking decisions that needs to be taken by the corresponding board of the corresponding meetings. As to insurance policies, what have we learned? Most of the insurance policies are currently enforced, especially or try to negotiate them, because now we understand this could happen. So that mitigate any liability vis-a-vis the third parties of the corporation. And finally, as to the financial health of the company, we need to see if the company, what is the current status of the company after this pandemic. We need to assess if we need to renegotiate our liabilities with our creditors. If that is the case, then we have the restructuring law, and this is a good moment to start thinking about that. We have a lot of restructuring, Law 141 as of 2015, and although we don't have, like, let's say, successful cases of restructuring, I could say that it's the law at least try to make the restructuring the rule and the liquidation the exception. So try to make the company running and survive. As to labor matters, I think this is the most important part, because company has the constitutional right, the constitutional obligation, sorry, to preserve the safety of the workplace and to preserve to guarantee the safety of the employees. And we need to segregate these parts into two times. First of all, what will happen before reopening the business, and what will happen after the reopening of the business. And before reopening of the business, it's the things that we need to take into account right now. We can start that from now on, so we can get prepared for the reopening stage. What will happen? What will be the first things to do? Make an inventory. Let's understand what is the physical condition of the employees right now. If they let's see which one of the employees are pregnant, which of them has pre-existing conditions such as diabetes, hypertension, a respiratory disease, or problems that may encounter problems if they had the COVID. And let's have another column of employees that already had the COVID or were in contact with persons that had the COVID or have the COVID. So this data will allow us to establish a protocol of entrance in the company, which is something that we will see after a while. By collecting this data, we need to take into account our data protection law, because health data is considered as a special protected data under the law. So we need the informed and express consent of the employees to provide the data for the collection and the treatment, because we cannot do a database of the health conditions of the employees without their consent. We should have that. So what will happen then? After the government issue the measures, we need to be alert on the measures and guidelines that the government will issue through the Ministry of Health and the Ministry of Labor. We will cancel the suspension of these employees, could be partial, could be total, that cancellation is through a notification to the Ministry of Labor, who in principle should notify the employee, but employers notify the employee directly to avoid any miscommunication. So that's the practice. Then what will happen with the data already collected? What will happen with those employees? You will establish, those employees cannot go to the workplace. So you will establish a timeline that those employees will stay at home, or if they will work from home, or the one that already had COVID will be on medical leave. You know, that's under our Social Security law. You have up to 26 weeks of medical leave, and it's a paid leave, up to 60% on ambulatory and 40% if you were in a hospital. So if you're in quarantine because you were in contact with other people, then you have to stay home, you work from home whenever possible. So before the employees get in the company, enter into the company, they must sign like an obligation, like a form, obligating themselves to keep the employer updated and informed on any cases of COVID they have been close to. If they have been close to someone with COVID, they need to disclose that information to the company, so the company be aware and could implement the correct measures in the workplace. Let's talk about the safety and health programs. This is something that we need to revisit beforehand. We need to revisit that before reopening the business, because although a lot of company has them, they don't have an updated version of the program. They don't have the committees registered at the Ministry of Labor, and doesn't have the latest meeting registered at the Ministry of Labor. So this is important, and mostly because it's very likely, if this is a speculation, that the Ministry of Labor will make inspections to the companies before allowing them to open. I don't know if they will sectorize them. I don't know if they will do a random inspections, but we need to be prepared. So the Safety and Health Program is based on the Decree 522 as of 2006. And for companies with more than 15 employees, you should have a committee of safety and health program, which will oversee that the program is implemented in the company. We have a live on Thursday, tomorrow, in our Instagram account, when we will talk more in depth about these programs and what should be the content of these programs. In any case, this should be in the checklist before reopening the business. All employees are mandated to abide by these rules, the rules that will be included in the safety and health programs. And if not, it will entail dismissal with cause, that what we call despido. So the employer can undertake dismissal with cause against the employee if they do not, if they are not abide by these rules. It is very important that the entrance protocol includes what will be the rules for the visitors as well, the employees and the visitors, both of them, because it's the only way that we could implement preemptive measures and avoid COVID cases or an outbreak in the work premises. What will happen after reopening? First of all, we need to verify if we comply with all conditions or requirements that maybe the Ministry of Labor and Ministry of Health will impose in the future. Undoubtedly, I think companies with this pandemic have understood that work from home is a great tool right now. The labor code is not prepared for that, doesn't have any provisions. We don't have any special regulations about that. So it's very important to have an internal policy. So employees that has such work modality could consent that. Also, if it is not possible, we need to imply the flexibility of the work shift. And we need to comply with the social distancing rules from between one employee and the other. We cannot have everyone as we were before. That's for sure. And I think labor inspectors will make sure that wouldn't be like that. So. What should we take into account? Well, in the policy, in the work from home policy, we need to take into account what will be how terms and conditions of working like this. And if some of the parties is in default on that with that conditions, then the contract will be terminated, or we can change the modality. Make sure that ongoing employees right now that are not working from home consent such change of or such change of the way to provide this kind of services, because you cannot change that unilaterally. And I mean the company cannot change that. Like, the company cannot say to employees, you know what, right now you will now work remotely, you will work from home. No, they need to sign something, sign a document changing the way the service is being provided. And still, there's a lot of challenges in our legislation on that regard, because we need to reinforce cybersecurity rules. We need to understand what will be considered a labor accident under such circumstances, who shall borne the cost of the electricity, the cost of the phone bill, and so forth. There's a lot of things to consider here. And as to engagement of new employees, we need to include a COVID test for the safety of the health of our current employees. And we need to be very careful to avoid discrimination here, because we cannot reject a prospect because they have COVID. If they tested positive, we need to have like some provisions when they consent that it should say, if you test positive and you have the other conditions required for the position, then the company will allow you to recover from this, something like that. But you cannot reject them by being positive. If they don't have the other conditions, then obviously there are other prospects, but be careful on this. As to the applicability of preventive measures in the workplace, this is a must. The Ministry of Health already issued a letter on March of this year on what are the things that we need to have in the workplace. Of course, you will need to have gel, soap, sinks, towels, everything clean. We need to increase our cleaning routine, encourage employees to clean in their desks, to preserve everything very clean. We need to provide as employers all the tools for them to keep everything clean, and keep them updated with information of the issue by the governmental entities, either by the Ministry of Health or by the Ministry of Labor. As to responsive measures, for example, if an employee tested positive in the workplace, what should we do? Well, we need to isolate the employee, be careful with the discrimination and on the workplace, and we need to put in quarantine the persons that work close to that employee, and of course put them working remotely whenever possible. And if not possible, they need to be suspended, but they cannot be in the workplace. As to the termination of contracts, we need to take into account two things. First of all, the possible allegation of an employee of an abusive exercise of the SAUCIO. The SAUCIO is a termination without cause in our legislation. And if that is the case, the judge will condemn the company with damages, and will understand that the SAUCIO was abusive. Sometimes they could also understand that that person needs to be reintegrated to the company. So that will depend. But there are, we have case precedent on that with a cancer patient, and she reached a favorable judgment on that regard. and about the mobbing in the workplace, especially with persons that already had COVID, and all the employees knows that. We need to be careful on that. We need to implement policies, non-discriminatory policies in the workplace, because the company could be liable for that. And what will happen with employees' death? That's my last topic. If an employee die of COVID or any other illness, labor code established an economic assistance, which is lesser than the severance amount, to the beneficiary that was already appointed by the employee at the time, or in the order provided by the code. Basically, it will be 15 days per year of service, and if less than 1 year, from 3 months to less than 6 months is 5 days, and for more than from 6 months to less than a year, 10 days. So I hand over to Caroline now who will outline the tax matters of this topic. And remember that you can pose your questions and we will address them at the end of the presentation. Thank you.
Thank you, Carolina. Hi, everybody. I'm Caroline Bono, head of the tax department at Peñarol Herrera, as well as for the accounting and tax compliance services provided under a P&H brand name Labor All. I will be providing you with information, updated information regarding the tax measures adopted in the Dominican Republic, the most relevant ones, as well as suggested tax measures post-lockdown. COVID-19 virus was declared as a pandemic on March 11, 2020 by the World Health Organization, and it immediately became a humanitarian crisis without precedent, something that no one was prepared for. However, it has brought countries and communities together for a joint fight against this virus. By the end of April, the pandemic had affected over 3.7 million people and taken the lives of 258,000. That's a lot. By May 4, there are 102 vaccines or candidate vaccines under investigation, 8 of which are being currently tested in humans as we speak. This is a clear indication that global unity towards one common goal has occurred. Upon such unexpected phenomenon, governments are adopting different measures to limit the propagation of the virus, to protect its citizens, the livelihood, as well as the sectors, such as sanitary measures, restructuring measures of its institutions, economic measures, monetary and fiscal measures. Additional measures have been included, such as social distancing, lockdown, curfews, and the closing of non-essential businesses and prohibition of any activity that could result in a conglomerate of individuals. So that being said, it has resulted in a sudden financial crisis for which most or a lot of companies have been affected. According to the Organization for Cooperation and Development, the OECD, and as expressed in the most recent virtual meeting made by the G20 countries, which are those that make 85% of the world's economy, the lockdown, according to the OECD, which many countries have adopted, will directly affect the sectors that represent 1/3 of the GDP in the most advanced economies. Furthermore, OECD states that for each month of lockdown, the annual GDP will decrease by 2 percentage points. Tourism, for example, tourism alone will be affected with a benefit reduction between 50 to 70%. As a result, many economies will enter into a recession. OECD understands that in order to address this impact, G20 countries should immediately address and adopt the following measures: recapitalization of the health and epidemiology systems, for example, issue macroeconomic policies regarding monetary, budgetary, institutional, lift commercial restriction, especially the ones aimed for medical supplies, provide aid and economical support to the most vulnerable countries, such as the Dominican Republic, share and implement the best practices to support the employees and all people whether these are employed or not, and especially the most vulnerable ones. Provide aid to small and medium entities or SMEs. Therefore, a joint document made or provided or elaborated by the OECD Forum on Tax Administration, the Inter-American Center of Tax Administration, or in Spanish, CIAT, and the Intra-European Organization of Tax Administrations was issued on April 21, which depicts the tax measures adopted globally by the tax administrations for entities, self-employed, and individuals facing the distress, financial distress due to the pandemic, with the intention to avoid higher levels of unemployment, interruption in the supply chain, and bankruptcy. The document intends for other tax administration to adopt these measures. Some of these measures have been already adopted by the Dominican Republic, such as additional time for dealing with tax affairs, extension of filing and tax payment deadlines, the reduction of penalties, tax payment deferrals, easier access to debt payment plans, and extension of its duration. With this brief description of where we are globally, and in order to address today's meeting points from a tax standpoint, the Dominican government has issued different measures from sanitary, institutional, economic, monetary, fiscal, among others, with the intention to tackle the effects of the pandemic. Briefly, the tax measures imposed from March 17 up to date destined to aid the taxpayers are as follows, and as indicated previously, we will only mention the most relevant ones. Regarding the annual income tax, extension has been granted to the deadline for the filing and payment of the annual corporate income tax return and of the annual individual income tax return. Taxes that are due, in case these are due, the taxpayer may pay these up to 4 equal installments interest-free. Asset tax has also been deferred and postponed, whether it is the filing and also the payment, interest, and there has been facility for its payment interest-free. Tax advance payments for fiscal periods of March and April have been eliminated. In fact, it was yesterday that the tax authorities issued the notice that the tax advance due on April will be eliminated. And this is applicable to all entities that are prohibited to operate during the pandemic as established by Presidential Decree 134/20, with the exception of the large taxpayers. However, if there is a large taxpayer that is unable to operate due to the pandemic, may also request to obtain this benefit. Income tax deductibility has been established on the co-payments or complementary payments made by the employers to its employees under the FACET programs, which is a fund for employee relief designed by the government, provided that these have complied with the prerequisites established by the Ministries of Finance and Labor. In addition, for this co-payment to be deductible for the employer shall make this payment to the same bank account that the employee receives the aid from the government. This complementary payment made by the employer is considered a salary. Therefore, income tax withholding applies. Regarding VAT or ITEVIS and excise taxes, extension for the deadline of the filing of the VAT return has for the months of March and April, or the tax periods of March and April, have been granted. Taxes that are due are subject to payments of up to 4 monthly quotes interest-free. There has also been an extension established to the deadline of the filing of payment of the excise taxes on fossil fuels and petroleum byproducts, as well as on special contribution for liquefied petroleum gas. 3 interest-free payments have been granted regarding the VAT on products derived from alcohol and tobacco. Excise taxes have also been granted with this benefit. Temporary suspension have been granted on the applicability on the VAT on import and local transfer on special pandemic needs or items such as surgical gloves, masks, sterilizers, respiratory machines, thermometers for clinical use, among others. Extension of the validity of the Free Trade Zone's VAT exemption card has been granted up to June 30th. Regarding tax debts, there have been facilities on its payments. There has been a reduction of 50% regarding the quotes due. There has also been the elimination of all surcharges and penalties on outstanding quotes. Quotes due on April, May, and June 2020 will be automatically extended for 3 more months. Regarding advanced pricing agreements, APAs, for the tourism, the tax authorities will not apply the rates established in these agreements for a 90-day period. And this is an important one. There is no filing or reporting obligation for the taxpayers that are prohibited to operate during this pandemic. There is a 30-day grace period granted, and it will begin to count when these entities resume with their operations. Taxpayers that have been operating during the pandemic are not subject to this benefit. In addition, the tax administration has postponed coercive collection procedures for April and May 2020. It is expected that this will be extended for a few more months. However, the notice has not been issued yet. And the new normal for the tax authorities, aside from reducing temporarily their collection will to focus on providing relief to the affected taxpayers due to the pandemic, is that many procedures can now be completed via their website. For example, tax ID requests and modifications, VAT and excise tax exemption requests, VAT return amendments for fiscal years 2019 and 2020 are among the procedures that can be made now via their website. The Dominican Republic has acted in a timely manner with the implementation of tax measures, including the most affected sectors, tourism, for example. However, they have taken a day-by-day approach, yes, which may bring upon speculation and tension between the sectors, rather if they would have approached this issue with a broader scope, maybe including the tax benefits and facilities for the next 3 months. However, it is our understanding that they will continue to issue measures depending on the development of the pandemic and the economic performance. The impact of the pandemic over the economy makes the tax efficiency an essential factor during the crisis, as its measures bring upon relief to the taxpayers, especially the SMEs, but also post-crisis with the resurgence of the economy. Regarding the resurgence of the economy, it is also worth highlighting that according to a recent statement issued on April 2020 by Alicia Bárcena, Executive Secretary of CEPAL, or the Economic Commission for Latin America and the Caribbean, according to this institution, the economic growth of all the economies of Latin America and the Caribbean will be negative, except for the Dominican Republic. The World Bank has also predicted this. So in this crisis, there is a light, and we should benefit from this. So what comes next in the fiscal arena? It's definitely a challenge, especially if we factor in the presidential elections, which are scheduled for July 5, 2020. We understand that there is room for improvement with regards with the tax environment. The following recommendation elaborated by our department based on private sector requests, the best practices by more advanced economies, OECD recommendations, could help the government to provide additional aid to the taxpayers. We've divided these suggestions between immediate tax measures and midterm tax measures. Regarding the immediate tax measure, we suggest apply tax credits to compensate current tax obligations and substituting the prerequisites of a prior full tax audit for a more expeditious procedure. Allow the reimbursement of tax credits, again, releasing the prerequisite of a prior full tax audit in order to allow the reimbursement. Reimbursement should not take more than 50 days after it is requested. 100% income tax deductibility of donations made due to COVID-19. Pursuant to the current tax law, donations are deductible up to 5% of the net taxable income. all expenses incurred by the entities in order to address the sanitary recommendations of the health authorities for a better and healthier work environment post-lockdown shall be accepted as an expense for income tax purposes. Elimination or reduction of tax advances for fiscal periods 2020-2021. It is fair to expect that most taxpayers will not have a net taxable income in 2020. Tax incentives benefits to entities that elaborate pandemic first aid products, which can motivate manufacturers to branch out and create jobs. This could help with the resurgence of the economy. And we are referring to items such as surgical gloves, masks, garments for first line of defense, any other material substances required in health facilities to address the pandemic. Currently, only VAT has been eliminated on the import and local transfer of these items. Elimination of the income tax on sales made from a free trade zone into the local market regarding these items. Implementation of tax measures for SMEs. For example, a tax credit could be granted to a company or a taxpayer that grants economic contribution or support to an SME or a startup project, for example. Regarding medium-term measures, that is upon the flattening of the curve of the pandemic, in order to help reactivate the economy, we suggest temporarily suspend the income tax withholding on salaries, thus reporting the minimum to the Social Security system so that the employee continue to contribute. Allow the deductibility of the tax losses in the same year instead of waiting for or applying the 5-year rule. This will be in consideration of the substantial losses that most companies will experience due to the pandemic, since more than 90% of the entities in the Dominican Republic have been prohibited to operate. Regarding intercompany transaction, this is from a transfer pricing standpoint, tax authorities shall allow the modification of the intercompany agreements regarding the terms, conditions, and pricing in order to reflect the reality of the pandemic, especially if there are intercompany loans, the interest rate should be modified and it should not bring upon issues for the taxpayer. In addition, establish a reduced VAT for streaming and for telecom services, eliminate the 1% asset tax, and regarding the asset tax, be reminded that before the pandemic, there was a bill, and there is still a bill in Congress, which reduced the asset tax from 1 to 0.5%. This bill was never approved. We suggest to eliminate at least temporarily. These type of crises may result in many companies entering into financial distress and leading to opportunities for organizations or reorganizations. Corporate restructuring, whether internally or with third parties, M&As, spin-offs, sales, strategic alliances, etc. From a tax standpoint, a simplified procedure should be considered in order to carry out these transactions before the tax authorities. And if a tax would result from these transactions, such as a capital gain tax, for example, we suggest its deferral and or reduction. Furthermore, we consider that this is a great opportunity for the Dominican Republic, for the government to revisit the National Development Strategy, particularly regarding an integral fiscal reform, simplification of payments processes, cut on disbursements and expenses of the government, and align the tax system to the COVID-19 reality, which is here to stay for a while. Studies have shown that it is healthier for a country to reduce its tax rate and broaden the base, because it is likely to increase the purchase power, increasing the consumption, increasing productivity, and generating employment. We also consider that this is a great opportunity to revisit the permit procedures for gold concessions, which is a commodity with increasing value. Special consideration shall also be granted to the nearshoring concept, which has been talked about for a few, or during the recent years, as multinationals are trying to bring production to the main market. which is the USA, and be less dependent on China and other countries. This will lower the cost of goods and expedite the procurement and production process. Will be key opportunity for DR and the other nearby countries. But we should consider if the Dominican Republic is prepared for the beggar thy neighbor policy, in which other countries may enact or create policies to attract investments to their countries, thus affecting ours. Is the Dominican Republic prepared to voice out all that we have to offer? We have many laws that provide tax incentives and a great strategically geographical location, but we need to voice these and simplify the processes to be able to benefit. We will respond to your questions at the end, and right now we will pass the mic to my colleague Felix Fernandez, who will talk about litigation issues post-lockdown. Thank you.
Thank you, Caroline and Carolina. Thank you for joining us. Today I want to discuss with you the litigation considerations after the lockdown, but in order to do that, we first have to know where are we. The current status of the litigation proceedings in the Dominican Republic are in two aspects. The first aspect is regarding the ongoing cases that were suspended because of the measures issued by the government. First of all, the majority of the courts are closed or have suspended their activities. Only the Constitutional Court and the criminal courts for certain cases are still working virtually. Those cases are the coercive measures and constitutional injunction. And recently, because of the spread of the COVID to the jail facilities, also were included the execution courts for changing the regime of the condemnation for the jail facilities in order to allow certain persons to get out of the jail facilities because of their previous condition in terms of health, in a way to address the possibility of a contagion. Also, all legal terms have been suspended for court cases and administrative cases. However, we have been appointed to represent clients during this term in order to allow them to defend themselves in administrative proceedings that are already ongoing, even though the administrative terms have been suspended. The bailiffs cannot perform their activities, their functions, and that is also something to consider. I'm not referring to arbitration, just court cases, because arbitration will depend on the arbitration rulings and the corresponding officers in charge of managing the arbitration. But I want you to know that the presidential decree ordered all chambers of commerce to close activities. Recently, the Chamber of Commerce of Santo Domingo has opened certain presidential activities, but arbitration is not included in those activities. In this scenario, what can I do with a new case? Well, for new cases in litigation aspects, there are some difficulties to file new legal actions because, as I said, bailiffs cannot perform their functions, and most of courts are closed. Even for criminal courts, you cannot file an accusation at this moment. So there's also the difficulties to enforce a judgment or to enforce an obligation because of the impossibility for bailiffs to act and of the impossibility to go to a district attorney in order to get the authorization of public force for the out-of-court proceedings such as embargoes and such. And also, right now, the judicial branch service is considering a revolution in the system, taking into consideration the impossibility to gather 100 attorneys in a courtroom right now and in the near future. The judicial branch is addressing virtualization and digitalization of all services, and that's ongoing and being studied and implemented. So knowing where are we can foresee where are we heading to in the litigation areas, but in two aspects. In the short term and medium term, we expect a progressive dismount of the restrictions imposed by the government, but with health protection measures imposed and the implementation of a digital justice project, as I say. These will present challenges at court because of the accumulation of proceedings. All the proceedings have been suspended, and some of the proceedings that the people and the companies want to file at court are waiting, expecting the open or reopening of the courts. So we expect a lot of cases to go to the system, to the judicial system. So it will accumulate a big amount of cases at courts. And we don't expect that at the beginning and the short term, the courts will be able to handle as much cases as fast as they were before the lockdown. Also, the implications of the term suspension, because the legal terms were suspended, and that means that after the lockdown and after the emergency declaration, the terms will continue where they were. They won't restart. And that's something that has to be considered. And the challenges of implementing the digitalization of the service in the courts will present several issues for the litigation aspects. We expect certain cases to increase, such as labor cases, cases of breach of contracts, even collection of debt, also insolvency and restructuring proceedings. We, as Carolina said, we do have a law, and we expect this, the reality of the COVID will increase the use of these proceedings for the companies in distress. And also we expect liabilities, filing liability lawsuits against companies and people due to contagion because of the general security obligation in contracts. But also we have to take into consideration something that has happened in other jurisdictions. The courts have been more lenient towards the debtors, and in the Dominican Republic, we have the ability to ask for a grace, a term for pay, a delay of the payment at court. And we expect that this will be a possibility, and also the possibility that this would be abused, a right to be abused by the debtors. Also, because of the suspension of the activities of courts, some people and companies have been watching alternative dispute resolutions, such as mediations, for certain cases that could not wait to be resolved after the lockdown. And on the long term, we see opportunities and challenges. Opportunities because the implementation of the digitalization of the services at courts could produce efficiency of resources, and also, if well implemented, could possibly reduce the litigation costs for the parties. And towards the long term, we see challenges and the legislation updates that would be needed for this new reality. And also the ability to resilience and innovation for success of the companies in this litigation aspects would be important to address and to benefit of these changes that we foresee, and to take acknowledge of this situation in order to better understand how to do business in the Dominican Republic after the lockdown. Thank you for your attention, right now we will address your questions, and I pass the mic to Carolina.
Sorry, apparently. Thank you. I was on mute. Thank you, Felix. Thank you, Caroline. We have now the Q&A section. We just have a few questions, and we hope we can answer them as you expect. One of the question is, in a previous live, I understood that consent, it's not necessary to change the workplace. Could you confirm if a letter will be sufficient? I believe that you referred to change the modality when I said the consent to change to work from home, because to change the workplace could be understood as changing the domicile of the company within the same city, for example. That's not the same. Now I'm changing the modality, how I provide the service to the company, and that will be under different terms and conditions, because obviously you need to ensure that we have that the employee has sufficient internet access at home, and sufficient data, sufficient phone minutes, time engage with their providers. They have the ideal space to work with, and most importantly, they have they can keep everything confidential, because that's the other thing. So also you need to ensure that you have the cybersecurity rules very very well enforced in your corporation. So it's not something that you just send them at home and that's it. You need to create terms and conditions that they need to be forced to comply with, and if in case of non-compliance, will entail the termination of the relationship. And because we don't have a law, we don't have a regulation, we need to regulate that in a contract. So first of all, a contract with those provisions will benefit the employer mostly. And about the consent per se, under these circumstances of pandemic, we can have grounds, and Felix can maybe explain better that from a constitutional point. We can have grounds to send them home, especially the categories that I already said in my presentation: pregnant women, the personnel that have certain conditions. Those ones, we don't need their consents to send them home, because we already have sufficient ground in a court to make them understand why we're doing that. What I mean is to change the way the company operates and send practically all employees to home because they want to reduce costs. So if that is the case, then we need to create terms and conditions, and employees need to consent them. That will be advisable. I don't know if Felix wants to add something more.
I think you addressed it correctly, and the difference between working from home or the change of the workplace. I think you addressed it well.
Okay, so the next question will be, what about employees who refuse to return to work? What actions can we take? Let's see. If you cancel the suspension of an employee, you remember that I said that you need to notify the Ministry of Labor. In principle, you know that our labor code is from 1992, so it was created understanding that they could notify all employees suspended, but not in a case of pandemic. So we will notify the Ministry of Labor, and the Ministry of Labor should notify the employees. And when I recommend that the company should also notify the employees through WhatsApp, through the emails, through a phone call, just notify them you will begin operations again, and your entry date will be X. If an employee says no or doesn't appear, then you can terminate employee. That will be the solution. This is for you, Caroline. The next question: do you have any information about the payment agreements with the DGII?
There are the agreements made prior to March 19, 2020 that are already in agreement, and the quotes are established with the tax authorities. Those are the ones that have special benefits. For example, they eliminate 50% of the quote, of the value of the quote, and they extend for 3 months the deadline of the quotes. For example, the quote that was due in April would be due in 3 months, and so on. However, the outstanding tax debts that are not under an agreement with tax authority prior to the pandemic, what they are applying is Articles 8 and 9 of the Fiscal Transparency and Revaluation Law, which approaches or addresses the tax debt. And that is, they will eliminate the surcharges, the 100% of the surcharges, and only apply the interest of the last year. However, the tax authorities are not in collection mode right now. They understand the pandemic. They are willing to help the taxpayer not become bankrupt. They are trying to provide relief in the best way they can, alongside with the monetary policies that are being issued, especially for SMEs, because the government is seeking to help recuperate and take out of the ICU the companies in financial distress. Therefore, also the collection procedures or coercive collection procedures have been put to a stop for now. So that is that regarding information on payment agreements. But what I do, or we do suggest, is that always be willing, always face the tax authorities, always be there. Try to address the situation, explain to them you can't, and they'll understand, but be there. That is very well accepted for the tax authorities. Mm-hmm. Also, there is another question. As a result of the lockdown, I have no way to pay my taxes or make any agreements. What can I do? Well, first of all, during the pandemic, there shouldn't be any taxes due because we are under the presumption or assumption that you are not operating because you are prohibited to operate. So taxes should not be due. Also, there is a specific notice establishing that for entities that cannot operate due to the pandemic, there will not be any obligations to until the pandemic is considered to be over, or at least the emergency state is lifted. So from that side, you are okay. However, if you have debts before the pandemic, then as I stated before, what they are applying is the last year interest accrued to the debt. However, they are not in a collection mode right now. They are not going to force you to pay, knowing that most companies cannot. So we suggest to approach the authorities. Always approach the authorities. Don't wait till the last minute. Don't wait for them to approach you, because then you will be under most vulnerable. And it is best if you approach them first and they see the willingness and try to comply with the tax obligations. And this is for Felix. Felix, you have a question. All my suppliers have failed in their services agreements. Can I sue them? They told me they can't work.
As I said, right now, filing a new lawsuit is not possible at courts. One of the suggestions we could address for these type of situations is trying to reach an agreement. We know that this situation has affected the possibility to operate to many companies and commercial individuals. And trying to reach a solution, a mediation between the parties is a possibility while the courts can open and new filing of lawsuits are available. That's one solution for the moment, but the difficulty of not being able to perform a bailiff act right now difficult or makes it impossible to file a new lawsuit. So I hope I have answered your question.
The next question is taxes. The DGI can exclude me from the RST for having failed to pay the tax in the moment because of the lockdown? No. Recall that there are different things to think about. First, they are not in a collection mode. Second of all, RST has been, deadline payments have been extended. Third, also the payment, the payment due has also been divided into quotes. So they will not exclude you from the RST for having failed to pay the tax. A lot of taxpayers, whether they are in RST or not, are going to have this issue, even with the facilities that the tax authorities have granted by dividing the payments into quotes. There are still going to be issues, so no, you will not be excluded from the RST for having failed to pay the tax in this particular moment. Now, when the pandemic is over, when things start running again as usual, then this answer would vary. Then there's another question, and I think it would be for you, Carolina. What can we do with the TSS collecting the payment to employers that have the contract of their employees suspended?
If they are suspended, they're not supposed to be at the TSS. So if you left them there because you really want them to have medical coverage, and I understood that because at the beginning, when the FASE program was issued by the government, the Social Security wasn't so clear, the Social Security coverage, and then they agreed that with the family insurance, which is the medical insurance that they have. But that was after that. So what certain employers did was to keep them at the Social Security in the meantime and pay at least a minimum quotable salary. I don't know if that is the case, or the case that maybe your payroll manager forgot to dismiss that part, because the SWIR Plus and the CIRLA are different systems. CIRLA is the Ministry of Labor, and through that system you suspend employees, and the SWIR Plus, which is the system of the Social Security, they don't link each other. So you need to do both things separately. If you didn't cancel the employees for those months, the employees were going to be suspended, then you have to pay them. I don't know, Felix, if you have like a procedure. I don't know any precedents, case precedents that you can show to the court that maybe they were suspended and it was a negligent that I left them in the Social Security, considering that they already have an agreement with the government that they will have the medical coverage to those employees. So it will be obviously a negligence from the company. So what can we do from the litigation part? Maybe we can do something about that.
Well, you know that the TSS gained personality recently through a law review. So we'll have to wait to see how they will enact that personality for the collection, because that was the main reason for that provision in the law, in the change of the law. So we will have to wait to see how will the TSS will enact that provision of the law.
Yeah, because the TSS have currently legal personality to go to court and and initiate a lawsuit against the companies. That was the recent amendment, one of the recent amendments made to the law of the Social Security law. So we don't have case precedents, but let's see. But they have the right to initiate a lawsuit against the company. We have another
Other questions?
question. What is the employee? No, the DGII comes first, I think.
What if the employee is pregnant and we are not paying TSS? Will she be covered?
I don't know.
That is the second before the last.
No, the problem of that is that she won't have, she won't have the maternity subsidy at the end. She won't, I mean, she will have the medical coverage right now because of the agreement that she had with the government. After May, because the agreement was for April and May, after May, she won't have any medical coverage, and she lose the maternity subsidy provided by the law, because you will have you need to have a minimum payments, consecutive payments to the Social Security for having that. And the employer just stopped those payments with the suspension. So if that is the case, she lost them as well. So she won't have coverage for the birth, and she won't have the coverage for the payments of the subsequent months, the maternity leave.
But she would be in time to the employer in time to correct this?
Well, they can correct that. So she may have the medical coverage now, but she lose the subsidy, because with the subsidy, you will have a minimum salary to a salary payments to the Social Security, and should be consecutive. I mean, she will start from day one right now, if they start now. That's why when our clients came to us with the suspension, we always said, remember that pregnant women coverage needs to be preserved. We recommend to let them, to preserve them in the Social Security system, so she won't lose this maternity subsidy in the future. Do we have another one? No?
No, I don't think so. No.
No, but that's it. Well, Felix, do you want to close?
Yeah, I will. Thank you for watching us. This video will be uploaded in the Pellerano Herrera channel in YouTube. For anyone who missed it, could be able to see it later on. And please stay in touch with our social media to know our next activities. And stay safe. See you soon. Bye.
Bye-bye.
I'm sorry, don't miss, remember that we have tomorrow health and safety programs under the law, very important during this transition period that we have. And as I said before, to be prepared for the reopening of the business, we need to ensure that we comply with those rules. So don't miss it. Thank you very much.